In May 2013, the Kern County Sheriff's Department became the subject of a federal wrongful death lawsuit following the death of 33-year-old David Sal Silva, who died in custody after a violent encounter outside Kern Medical Center. The litigation followed a high-profile investigation into the actions of several deputies and California Highway Patrol officers who used batons, a K-9 unit, and physical restraints against a perceived threat. According to the investigation, the official coroner's report, conducted by the same department, involved in the incident pursuant to California Government Code 24,000, which allows the sheriff to also act as the coroner, attributed the death to natural causes and drug intoxication. However, independent forensic analysis and witness testimony suggested that Silva died of positional asphyxiation, a condition in which the body's position physically prevents adequate breathing while being held face down in a hobble restraint. The case was further complicated by evidence that deputies had seized cell phones from bystanders who recorded the incident. These actions led to allegations of a coordinated effort to suppress digital evidence, which constitutes spoliation of evidence under Federal Rule of Civil Procedure 37. On September 15, 2014, Deputy Jeffrey Kelly, the first the deputies present at the scene, was subpoenaed to a deposition in the case. A subpoena is a legally binding court order compelling a witness to appear and provide testimony under oath. Deputy Kelly arrived at the scene and found Mr. Silva asleep. To wake him, the deputy performed a knuckle rub, which is a painful stimulation technique used by healthcare professionals and emergency responders to assess a patient's level of consciousness. Mr. Silva woke up in a state of panic and confusion where the escalation of the situation became. One of the plaintiff's attorneys, Thomas C. Seabaugh, then began his line of questioning.
Obviously, as a canine officer, that means that you have a canine partner with you who can, as a tool that you can use in carrying out your responsibilities. Is that right?
Yes.
And your canine partner at the time of this incident was named Luke. Is that right?
Yes, my partner is Luke.
Has Luke been your partner from late 2011 to the present?
Yes, he has.
Were you involved in training Luke?
I was.
Does Luke have any particular expertise? For example, does he specialize in sniffing for drugs or finding explosives or being used as a weapon, or can he do all of these things?
Luke's trained in both narcotics detection and patrol work.
And patrol work would include using the dog as in the sense of using force. Is that right?
He's I would consider him an apprehension tool. Yes.
Apprehension. So can you take me through some of the training that you've done with Luke to enable him to be an apprehension tool?
The school I went to, the Handler School, I can't think of the name off the top of my head. It was 8 weeks long. We worked both in narcotics detection and patrol work, apprehension. Further, every month we train 20 hours a week per post standards. No, excuse me, 20 hours a week. It's 20 hours a month. I apologize. It's a 10-hour formal training every other Wednesday. And on top of that, we also train nightly with our canine partners.
So with respect to the 8 weeks in apprehension training, was that classroom videotape training, or was it more hands-on out in the field?
It'd be more hands-on, real-world scenarios, circumstances.
What sorts of things can Luke do in terms of his apprehension skills? Or can you and Luke do as a team in terms of apprehension?
My objective's vague, but go ahead and answer if you can.
When you give the command "Pocken," what does Luke do?
He would apprehend the subject that my attention was towards. And
is that, when you say apprehend, does he bite the person that you say? In other words, when you give this command, he has some object that his attention is on. Is that right?
Correct.
And so if you say "Pocken" and his attention is on something, that means to go and do what to that person?
To apprehend them.
But what specifically do you mean when you say apprehend? What
He
is
would
the dog
apprehend.
doing? What is the dog doing to apprehend the person?
He would be biting them.
Does he have a particular spot on the body that he's trained to bite?
Not in particular. We try to train arms and legs.
Does he make a distinction between, for example, grabbing somebody's limb to immobilize it and biting to to cause an injury to the person.
I'm object to speculation, but go ahead and answer it if you can.
Could you repeat the question? I'm sorry.
Perhaps that was a little bit vague. I'm all prepared to move on and maybe return to this later. Do you have training as to when it's appropriate to use the police dog to apprehend somebody?
Yes.
Also, you have had training with respect to the use of police baton,
Yes.
and you have training as to when that baton can be used.
Yes.
You've had training with respect to the use of tasers,
Yes.
and you have training as to when it's appropriate to use a taser.
Yes.
You have training as to the use of pepper spray,
Yes.
and you've had training as to when it's appropriate to use pepper spray.
Yes.
Officer Kelly asserts that the deployment of his K9, Luke, must be evaluated based on the specific apprehension tool protocols established during his certification and maintained through POST standards. POST, which stands for Peace Officer Standards and Training, is the state-mandated body in California that dictates the rigorous curriculum and ongoing requirements police K9 units must meet to be legally authorized for field work. Compliance with POST standards is not merely a departmental preference, but a legal prerequisite for the lawful deployment of a K9 in the field, serving as the minimum standard of care in a civil rights litigation context. According to the training protocols, patrol work specifically includes the use of the dog as an apprehension tool. The handler must master a series of verbal commands, most notably the command "packen." This command, derived from the German word for to seize, triggers a programmed response in the K9 to identify, physically subdue, and attack a targeted subject. However, under Ninth Circuit precedent, such as Chu versus Gates, the use of a bite and hold K9 is classified as a significant force that occupies the higher end of the force spectrum, just below deadly force. In this case, Mr. Silva was still stunned and was unaware of what Deputy Kelly was asking him, showing that he was not trying to fight or flee.
Let's talk a little bit about the incident itself. May 7th, 2013. Is that your understanding of when the incident took place that we're here to talk about today?
I believe so, yes.
You were on duty.
I was.
When did your shift start?
I believe it started at 8 p.m.
And how long did that shift last?
That day was longer because of the interviews.
If this incident hadn't happened, how long would your shift have lasted?
10 hours.
You were in uniform?
I was.
You were in a marked vehicle?
Yes.
You were driving?
Yes.
Were you assigned to a particular area?
No, not in particular.
You were by yourself?
Yes.
With obviously your canine partner.
Yes, Luke was with me.
At some point, you responded to a 647F intoxicated person call. Is that right?
Yes.
You're saying that you responded at some point in the evening of May 7th, 2013 to an intoxicated person call. Is that right?
Yes.
But you're saying you don't remember exactly what time it was?
I'd say between 10 and 12 o'clock at night, 10 and midnight.
Okay. What was that call came over the dispatch?
It didn't come over the dispatch, no. There was a call pending for service.
And so in what form did that information come to you? Was it over the radio? Was it over a computer terminal? Or how did it work?
Over the MDC, the computer in my car.
What was that acronym you just used?
MDC.
MDC. What does that stand for?
I believe multi-data computer. I may be wrong. It would be a normal looking computer screen in the car.
Okay. Have you ever seen a printout of that information in between the incident and today?
I believe I have, yes.
And when did you see that?
Would have been a few weeks ago.
Now, at the very beginning of the deposition today, I asked you what documents you reviewed in preparation for your testimony today. I don't think you mentioned the printout from the MDC terminal. Is there any other documents that you reviewed in connection with the incident in this case?
I'm object as argumentative. He didn't say he reviewed it in preparation for his deposition.
Let me just ask it this way. Over the past 2 weeks, have you reviewed any other documents other than the ones you've told us about so far today?
I believe I did see the printout, the iNet viewer, some of that, and then just mainly my interview with detectives, my statement.
Okay. So when you received the information that there was a 647F intoxicated person call, that came over the MDC, is that right?
Yes.
There was some text on the screen that indicated what the nature of the call was?
Yes, we're able to pull calls up and see what's pending in what area.
So with respect to this call, do you remember specifically what the text was, or maybe to what effect the text was that you saw on the screen?
I believe it was a subject, an intoxicated subject at Flower and Palm. I believe the reporting party, the person that called the sheriff's office, was a security guard with KMC.
Do you recall whether there was any other information, other than what you've told us so far, in that MDC entry?
Not that I can recall, no.
Did you have any information from the MDC that the person was on drugs?
Not that I can recall, no.
Did you have any information that a crime had been committed?
I don't believe so, no.
Do you have any information that anybody had been injured?
No.
Did you have any information as to who the intoxicated person was from the MDC entry?
I believe there was a description, but other than, as far as a name or anything like that, no.
What was the description?
I believe it may have been a clothing description. I don't really remember, like, in detail what the description was.
Did it indicate whether the intoxicated person was male or female?
I believe it may have said male, yes.
And you said it gave some description as to what clothing he was wearing, but you don't remember specifically what it was?
Not specifically, no.
Obviously, you didn't have any information that as to whether the person who was intoxicated had a criminal record or not?
No.
There was no warrant out for this person's arrest, as far as you knew?
I don't think we'd be able to get that information without his name. Yeah.
Well, I'm just trying to determine what information
Right.
you had and what information you didn't have.
Okay.
So you didn't have any information that this person had committed a crime and you needed to go out and arrest him?
No.
Deputy Kelly's testimony suggests that a determination of reasonable suspicion or probable cause must be grounded in the specific data points transmitted through the MDC. MDC stands for Mobile Data Computer, a system utilized by officers in their patrol vehicles to view and manage pending for service calls without direct verbal dispatch. When an officer identifies a call on the MDC, the system displays a series of electronic screens that include descriptors of the subject, the reporting party, and the specific penal code associated with the incident. In this instance, the call was categorized under California Penal Code 647 AF, which pertains to an intoxicated person in public. Procedurally, a 647F designation is an arrest, but this does not make exceptions to the use of excessive and unreasonable force. Deputy Kelly admitted that the MDC system did not indicate that a crime had been committed or any type of drugs were used by Mr. Silva. This absence of data is critical because, under the collective knowledge doctrine, an officer can only rely on dispatched information if the initiating agency actually possessed articulable facts to support the intervention.
After you received the 647F intoxicated person call, you went directly to the intersection of Flower and Palm?
Yes.
That's Flower Street and Palm Drive.
I believe so, yes.
And it took you less than a minute to arrive, didn't it?
I was pretty close, yes.
Now, did you have, before you arrived and got out of your car, you got out of your car at some point after you arrived, is that right?
Yes.
Did you see Mr. Silva before or after you got out of the car?
Before.
Before you saw Mr. Silva, did you have any other information about this intoxicated person other than what you'd received over the MDC system?
No.
Did you ever make a dispatch over the radio that you were responding to this call?
I believe I notified dispatch that I was in the area, yes.
Was there a response from dispatch?
I believe so, yes.
Have you ever listened to a dispatch tape of your dispatches and the responses?
I have not heard that tape, no.
But as far as you remember, all you said was that you were going to go out and respond to this call, and there was some acknowledgement that came back.
Correct.
Did you receive over the dispatch tape any additional information about this intoxicated person that you were about to make contact with?
Not that I can remember now.
So other than what you've told me so far, you didn't have any additional information about Mr. Silva before you actually saw him on the night of May 7th?
Correct.
Is this the first 647F call that you've responded to in your career as of May 7th, 2013?
No.
You've been on previous calls?
Yes.
Do you recall approximately how many?
I don't.
What would it be, more than 10?
I would say so, yes.
More than 20?
Probably yes.
Less than 50?
Maybe less than 50, around 50.
What does 647F mean, and what does that code stand for?
That's California Penal Code for public intoxication.
So when you were responding to this call, what were you intending to do when you made contact with a person who was the subject of the call?
Check the subject's welfare.
So you're trained, aren't you, that as a sheriff's deputy, occasionally in the course of your duties, you'll come across people who are in need of medical assistance?
Correct.
And you're trained that you should either render or summon aid to these people when you encounter them?
If I'm able to, yes.
So one of the things you were going to do on May 7, 2013 is determine whether Mr. Silva was in need of any medical attention.
Correct.
And if you determined that he was in need of medical attention, you were planning to summon aid for him, is that right?
Yes.
When you saw him, what did he appear to be doing?
Appear to be passed out.
Can you describe where he was when you first saw him?
I believe he was on the southeast corner of Flower and Palm.
He was lying on the ground?
On the sidewalk, yes.
Was he face down or face up or on his side?
I believe he was on his side.
He did not appear to be moving?
He appeared to be, he was breathing, but not moving, no.
When you first saw him, did he appear to have any injuries on him?
Not that I could tell.
Was there any blood on the ground when you first saw him, near him?
Not that I can recall.
Did he appear to be dying to you when you first saw him?
No.
Deputy Kelly reinforced his actions when he arrived at the scene. A public intoxication call is not inherently a criminal enforcement action. It is frequently treated as a public welfare matter requiring assessment rather than immediate apprehension. This initial phase falls under the community caretaking doctrine, an exception to the Fourth Amendment's warrant requirement that allows officers to engage with citizens to ensure public safety or provide aid rather than to investigate a crime. According to Deputy Kelly's testimony, the standard procedure for such a call involves a welfare check, a preliminary assessment of a subject's physical state to determine if medical intervention is required. He asserts that upon arriving at the place, he followed protocol by first notifying dispatch of his presence. By testifying that Mr. Silva showed no visible injuries and did not appear to be dying or struggling at the moment of arrival, Deputy Kelly's statements create a critical point of comparison for the subsequent escalation of force.
So after you first saw Mr. Silva, let me just walk me through step by step everything that you did. So You stopped the car at some point,
Yes.
and you got out.
Yes.
And then what did you do next?
I turned on my spotlight. I guess I would turn on my spotlight before I got out of the car, and then I walked over to Mr. Silva.
The spotlight is that's an apparatus on your patrol car itself. Is that right?
Correct.
And you pointed it in Mr. Silva's direction so that it would illuminate the area where you're going to make contact with him.
Yes.
And are you trained to do that?
Yes.
And then you approached Mr. Silva.
Yes.
And then, so what did you do when you approached him?
Walked over to him. I identified myself as a deputy, as the sheriff's office, and I was trying to check on him, ask him if he was okay.
Do you remember specifically which words you used when you were approaching him?
Not specifically. It would have been something to the effect of, sheriff's office, are you okay?
Did he respond?
No.
Was this before or after you had the conversation with the homeowner?
I believe it would have been before.
So after you say sheriff's office and ask him if he's okay, and he doesn't respond, what do you do next?
I kept trying to wake him up, check on him, see if I can get a response for him, see if there's anything I can help him with.
You performed a sternum rub on him at some point, is that right?
At some point, yes.
So when you say you were trying to wake him up or ascertain if he was okay, were you physically touching him?
Yes, I believe I grabbed him, maybe tried to move him, wake him up, get his attention.
And did he respond to that?
He had started to come to several times. He opened his eyes a few times, but I never got a response from him.
When you say you never got a response, he never actually spoke any words in response to what you were doing?
He spoke words, but it was nothing I could understand. I was never able to make out anything he was telling me.
What is a sternum rub?
That's I'm trying to think of the word. It's a procedure I've seen used to try to wake an intoxicated person, get their attention.
Were you trained in the use of a sternum rub by the Kern County Sheriff's Department?
I don't recall having any training for that, no.
And you said the purpose of the rub, and I don't want to mischaracterize what you said, but the purpose of it is to try to wake up an intoxicated person. Is that what you understand the purpose of the sternum rub to be?
That, and to see if they're responsive.
I
I guess if someone was unresponsive, it wouldn't be effective.
What were you trying to do with the sternum rub when you performed the sternum rub on Mr. Silva?
I was trying to wake him up to determine what was wrong with him.
You said that before you had performed the sternum rub, in that 4 to 5 minutes, he was moving and making various noises. Is that right?
Correct.
So obviously he was responsive to a certain degree. Is that right?
Somewhat.
But you were trying to sort of wake him fully up by doing the sternum rub. Is that right?
Yes, I wanted to speak to him.
Have you ever had a sternum rub performed on you?
I haven't.
Approximately how many times before the incident in this case had you performed a sternum rub?
I don't know if I ever had.
Had you seen other deputies perform sternum rubs
I have, yes.
before the incident in this case?
Yes.
What usually happens when you perform a sternum rub on somebody who's conscious?
I don't think you would perform it on, perform it on somebody that's conscious and alert or awake.
A sternum rub is, it's uncomfortable, isn't it? Isn't that the idea behind it?
I think so. I think it's, I've never had it done, like I said, but I'm sure it would get someone's attention.
When you've seen it performed on people, have you seen people cry out when it's done?
I haven't.
I'm sorry, did you say you had?
I'm sorry, I have not. I haven't.
Did you have your conversation with the homeowner during the 4 to 5 minutes before you performed the sternum rub?
I believe the homeowner came out. I don't know if we had a conversation.
Did you say in your recorded statement that the homeowner had come out and asked if everything was okay?
Yes. What I mean by conversations, I didn't speak to him for a long period of time. I believe he asked me a question and I explained to him that the subject was passed out and I was trying to wake him up.
Okay, so that was basically the substance of your exchange, if not conversation, with the homeowner. Is that right?
Correct.
The homeowner asks if everything's okay, and you said this person is passed out. And then the homeowner went back inside the residence. Is that right?
Yes.
And you're saying this happened before the sternum rub?
I believe so.
When you watched the surveillance video that we talked about earlier, can you identify the point on the tape when you performed the sternum rub?
I can't. I believe the footage that I have viewed was after that had taken place. Would you mind if I take a drink of water?
No, by all means.
Deputy Kelly explained his reasoning to do the sternum rub on Mr. Silva. He defined it as a procedure used to elicit a response from an intoxicated or unresponsive person by rubbing knuckles firmly against the sternum, or breastbone. Deputy Kelly admitted that he had no formal training from the Kern County Sheriff's Department regarding the application or safety of this technique. This admission is legally significant under the failure to train standard established in City of Canton v. Harris, which holds a municipality liable if its failure to train employees in necessary skills results in a deliberate indifference to constitutional rights. Doing so, Mr. Silva woke up in shock and with pain without understanding what was happening in the moment, which, according to the deputies, was the reasoning of the escalation. Under the Federal Rules of Evidence, Rule 1002, the original recording of an event is the preferred form of evidence. Additionally, the Federal Rule of Evidence 106 allows a party to require the introduction of any other part of a recorded statement that in fairness ought to be considered at the same time. Any gaps or missing portions of surveillance footage may raise questions of spoliation if it can be shown that the evidence was destroyed or withheld. Consequently, Deputy Kelly asserts that he cannot identify the specific moment of the sternum rub on the tape, as he believes the recording captured only the aftermath of his initial physical contact with Mr. Silva. This lack of pre-incident footage is a hallmark of spoliation arguments, where the absence of the triggering event would prevent the jury from seeing if the officer's initial force was truly justified. In May 2016, Kern County reached a formal settlement agreement resolving the federal wrongful death lawsuit filed by the family of Mr. Silva. The settlement reached a value of $3.4 million before the case went to trial. It was split among Mr. Silva's family, including his 4 children. Deputy Jeffrey Kelly and the other involved officers were not held personally accountable for the payment. Under the doctrine of indemnification, specifically California Government Code 825, government entities are required to assume financial responsibility for civil judgments and settlements arising from the on-duty conduct of their employees, shielding individual officers from personal financial liability even when their actions are found to be constitutionally deficient. The settlement resolved the civil wrongful death lawsuit. The involved deputies remained on the force, and the Kern County District Attorney's Office declined to file charges or any type of punishment, stating that there was no evidence of a crime despite the significant civil payout. This case illustrates how important it is for depositions to rigorously review the facts of a case. Over the course of the litigation, the deposition methodically walked through the critical timeline of Deputy Kelly's actions and the knowledge he received through his training and experience in handling such encounters. By challenging the improperly applied characterization of the force reflected in the coroner's report, Mr. Seabaugh counsel sought to dismantle the department's claim of a routine restraint, emphasizing that Mr. Silva was essentially suffocated under the weight of multiple officers. While in a state of physical distress, he was never given the opportunity to speak, Ultimately, the legal pressure surrounding the investigation's core contradictions reflected the case's constitutional failures. Rather than allowing the official report to serve as an absolute shield, the litigation forced a reckoning over whether Mr. Silva's movements were combative or the predictable, desperate response to positional asphyxiation. This mounting evidence of excessive force and the controversial seizure of witness evidence paved the way for the $3.4 million settlement. Now, let us know if there is a case you would like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe so that we can help promote a more informed society.